Smart kid.
Thank you.
That's great.
Okay, well, welcome everyone. I'm Diane DiGianantonio. I'm co-president of the Canton Area League of Women Voters. I'd like to inquire if there are any elected officials or people running for office here with us today. Sometimes we have them, but I guess not right now. So I'd like to extend a special welcome to the students from Central Catholic. How about a round of applause? It's terrific to see you all here. I'd like to take a few moments to provide some background information about the League of Women Voters. Our history started with the suffragists who fought for more than 70 years to secure the right for women to vote in this country. They won it in 1920 with the passage of the 19th Amendment to the U.S. Constitution. I'm sure you students all know about that. That was 122 years ago. When women achieved the right to vote, many suffragists recognized that people need to understand how our government works and learn about the policies and people who were vying for their votes to represent them. Thus, the League of Women Voters, which, by the way, welcomes men, was founded to provide non-biased information that voters needed before they cast their ballots. We believe voters can make their decisions best when they can study the information for themselves. Just this week, we published the popular and highly respected League of Women Voters 2022 Voters Guide, which is available in libraries and other sites throughout the community. Many thanks, and this will surprise her, many thanks to our Vice President and all-around wise woman, Mimi Bogard, here. And Carol Schonhoff, who's on our board of directors. They have spearheaded this effort for several years. We're committed to supporting democracy in nonpartisan ways. We never endorse candidates or political parties, but we do study important issues of our time and vet them thoroughly to determine whether we will establish a position on any issues and advocate for them with the Ohio or national legislatures. For example, we have taken a position against gerrymandering since the 1970s, when the Democratic Party was guilty of drawing bad maps. We also have a statewide league commitment to supporting a well-educated public through high-quality public schools. For that reason, earlier this year, we hosted 2 community education programs supporting public schools. One was focused on honesty in education, and the other about fully funding public schools rather than Ohio's expanded voucher plans that divert taxpayer money to private schools. This evening's program is the brainchild of Amy Drusi, a former League co-president and emeritus professor of social sciences at the University of Akron. You may hear a word or two about the University of Akron today. We are extremely grateful for the work of Joe Martuccio, who intentionally selected and recruited tonight's presenters to represent a wide range of opinions about this ballot issue, which is a proposed amendment to the Ohio Constitution related to bail reform. More broadly, this all-volunteer organization works very hard to live up to the League's motto, making democracy work. Members here tonight have volunteered as greeters, registrants, timekeepers, and question collectors. We invite you to join this wonderful organization. Membership brochures are on the back table, and I hope you pick one up and choose to join us. After years of sponsoring candidate forums and other educational programs, we've learned a thing or two. One is to request that you please turn off or silence your phone. Now would be good. Kindly note that taking pictures or videotaping during the presentation is not allowed. The video department here at Timken Commons is recording the presentation, cameras up there, and it will be posted to our website and the YouTube channel within a few days. Encourage your friends who may have missed it tonight to view it here. You may choose to review it again yourself. Now, we've reserved some time for questions after all the panelists have shared their remarks. You can use the index card on your chair to write your questions, and our members will pick it up as we start the Q&A section. If you wish to address your question to a specific panelist, please indicate that on your card. Your program agenda offers brief bios of each speaker. To allow more time for questions at the end, we've arranged for Joe to introduce each one with some personal comments, which I don't know what those will be, before each person speaks. So Joe, let's get started with your opening comments.
Thank you, Co-President DiGiantonio. Thank you so much for welcoming us. Thank you, Dr. Shriver, Juicy, for reaching out to us. Thank you to all the members of the League of Women Voters. Congratulations on your century-plus mark. You do wonderful work. And thank you all who have attended. You're giving up your evening's time. At least we're not competing with the Guardians tonight, when they whoop the Yankees tomorrow. But thank you so much for making time. You are rare creatures. You just don't, and the students, it's good to see you, even though I know it's extra credit, it's good to see you. You are rare in the sense that you just don't respond to sound bites and biased TV commercials. You want to dig deeper. You want to understand the issues and the candidates, and we applaud you for that. We're all very grateful to you for being here, and we're grateful to Bill Widener and the Canton City Schools for making this a video recording that will be available later, as was mentioned by Co-President DiGiantonio. So again, thank you all. I want to start off with a question. Here's how it's going to roll. Each of the five of us, will spend several minutes talking about issue one in general, or in particular from different points of view. You've had the biographies of each of us, I believe, handed out to you, so maybe you've had a chance to see that. We all represent different aspects of the criminal justice system, and this is a criminal justice issue, mostly. You'll understand that in a few moments. So we wanted to go one at a time, and I will introduce each of them and just add a few personal notes, as was mentioned, because I know secrets about each of them. And then, we'll run up to about 8 o'clock or less, and then we want to leave some time for questions and answers to individual panelists or all of us as a panel. First thing I'm going to ask you to do is take a look at something you were handed out, if you have it. It's a reprint of issue one in your handout opposite our biographies. And this issue, when Dr. Juicy first approached me with it, I thought, well, this shouldn't be too complicated. Everybody's for safety. No one wants hurtful people out on the streets, right? We can all agree on that. Well, bear with us. It's a little more complicated than that. So if you've got it in your hand, issue one will be on the state ballot, and early voting began yesterday, to require courts to consider factors like public safety when setting the bail amount. So far, so good. Require, we'll see. So it's a proposed amendment to our Ohio Constitution. This isn't the Ohio Revised Code, the Ohio Administrative Code. This is the Ohio Constitution that they are seeking to amend. It was proposed by a joint resolution of the General Assembly to amend Section 9, Article 1 of the Constitution of Ohio. Now, a joint resolution of the General Assembly. Most, if not many, of the proposed amendments to the Ohio Constitution are citizen-driven, to clean up redistricting, which has been a lifelong goal here, to deal with marijuana. This, though, was not initiated by the citizens of the state of Ohio. This is going to be on the ballot because the General Assembly passed with enough votes to make it so. They needed 60% of each chamber, 60% of the House and the Senate to get it on the ballot. This is a fact. I know we're trying to be nonpartisan and only be as neutral as possible. But it made it to the ballot by a vote of 60% of the Republicans in the House and 60% of the Republicans in the Senate, or so. Only Republicans voted to put it on the ballot. Every Democrat voted to not put it on the ballot. They opposed it. We'll talk about that. to read on. It would require Ohio courts, when setting the amount of bail, to consider public safety. Yeah, that's a home run, including the seriousness of the offense, as well as the person's criminal record, the likelihood that they'll return to court, and any other factor the Ohio General Assembly may prescribe. The Ohio General Assembly may prescribe. Legislators in Columbus, not judges, not justices. And it will remove the requirement that the procedure for establishing the amount and conditions of bail be determined by the Supreme Court of Ohio. Yeah, bye-bye. You know, we don't need you, justices. I'm being a little flippant, maybe I shouldn't, but I want you to understand this is good stuff. This is well intended, but we have to read it a little more closely, and that's why we're here, to help you understand it. A couple more general remarks, and then I'll turn it over to the next person. You know, again, we all want the same things. We all want people to have civil rights. We all want criminals off the streets. We don't want people awaiting trial who may be dangerous to be released, because you've all seen the extremes on television or read about it perhaps on social media. We all know about the case where so-and-so got out of prison because some soft-hearted judge, you know, let him out, and he hurt or killed someone while he was out awaiting trial. Now remember, the United States Constitution and the Ohio Constitution say you're not to be held in prison or jail with excessive bail, too much bail. So on the other hand, you've probably seen the story or read about the mom, for example, who was arrested and jailed and couldn't make bail and wasn't a very dangerous person. And as a result of not being able to make bail, she lost her job. And as a result of losing her job, she couldn't pay rent, and she lost her home. And she and her family were homeless. So there are the two extremes that I'm sure you've either seen or read about being thrown at us. In the recent decade or so, the judge to my right and several other people, I believe the person that's public defender to my left, have spent some time in oversight groups here, and even in Stark County, there's a criminal justice oversight group, looking at how fair have the guidelines been. Have they affected poor people or people of color disproportionately? Are they fair? So there was some discussions about that, and the courts have been working on that for a while now, and you'll hear about that. So with that, there are different factors here. Nobody is against safe streets. Nobody is against dangerous people being held in check. There's an issue here we'll get into about, you know, this balance of powers. I'm gonna before I introduce the next person, I want to ask you a question. High school civics. How many branches of government are there? 3. Can you name them? Judiciary, legislative, and executive, right? Right. Aren't they all supposed to be checks and balances on each other? Right. Today, I don't know how many of you had the time to see it, but you'll hear about it tonight. One branch of the federal government was talking about another branch of the federal government. A select House committee from the House of Representatives had a hearing about a former chief administrator of the federal government. And you'll hear much more about that when you go home. And you don't have to rush home again because the Guardians aren't playing. So with that, I want to introduce our next panelist. You probably read here that he's been a professor of law at the University of Akron Law School. You'll hear about how Tammi used to work for him in his appellate review office and inmate assistance when she was at the clinic at the Akron Law School. He graduated from Akron Law School with his law degree. He's originally from New York State. You can see all that. What you don't know is that he was also, for a decade at least, the federal court-appointed monitor to look in on the Summit County Jail and their conditions and the conditions of the inmates. So he's very familiar with the criminal justice system. And again, he hired Tammi, so he's a remarkably astute person. He and I have been helping out with the local NAACP. There are a lot of dots here, along with Dr. Larry Bowe back there. As I introduce each person, I'll tell you a little bit more about the dots that are connected. Mr. Professor J. Dean Carro.
Thank you, Joe. Anytime you talk about a constitutional right, can you hear me okay? Anytime you talk about a constitutional right, you're talking about conflict. So, for example, whip out your constitutions. You'll carry a copy of the Constitution. You can see how long I've been carrying mine, the shape of it in my back pocket. Well, in any constitutional right setting, whether it be the federal constitution or the state constitution of Ohio, there's always a conflict in those rights. So let's take the First Amendment, for example. I can say pretty much anything I want to say about a matter of public interest. But what I cannot do without some possibility of a lawsuit is I can't make a false statement in public about Joe that I know to be false. I cannot do that. That's not protected by the First Amendment. Why? Because we don't see that as part of the value of the First Amendment. So when we talk about the excessive bail requirements in the U.S. Constitution and in the state constitution, what are the conflicts? What are the tensions? On the one hand, we have the desire to keep the community and potential victims and potential witnesses safe from retribution by the defendant, the suspect. So that's a community interest, that's a state interest, that's a government interest. On the other side, we have the interest of the individual defendant. And the presupposition is that bail will be set so high that the defendant cannot make bail and will have to stay in jail. I've spent, as Joe mentioned, I spent from 1983 to 1993 every Friday for 4 or 5 hours in the Summit County Jail. Not a fun thing to do. But in the jail, I would talk to inmates, I'd talk to deputies. So of all the people in this room, I probably have spent the most time in jail, I would think. Let's hope. Oh, should I get closer? Is that it? Okay. How's that? Oh, hey, God almighty. Okay, so that's one of the tensions. Let's talk about the interest of the defendant. If you're in jail, you're not usually going to associate with a bunch of very nice people. They're going to be people who are rough around the edges, may have criminal backgrounds. It'll be difficult. It also stresses your mental health if you're there for a prolonged period of time. So if you can't make bail because you don't have enough money, you're going to sit in jail for a long period of time. So number one interest is your mental health. Number two, you may lose your job. Now that may not be that big a deal now because the balance has shifted to employment, to employees, but it's still a matter of interest to the individual. If I lose my job, I come out, I've got no money, I can't support my family. From my perspective, the biggest interest from the defendant's viewpoint is the presumption of innocence. We all are presumed innocent until the government proves its case against us beyond a reasonable doubt. And that is the level of certainty you want to have in doing the most important things in your life. What would those be? Buying a house, buying a car, deciding whether to get married in most people's cases. You know, is this something I really want to do, commit to financially or for the long term? So we're presumed innocent. We go to jail and we sit there. The biggest problem for me as a lawyer is this. When my client tells me what his or her defense is, let's say, for example, it's alibi. The government has the burden of proving identity beyond a reasonable doubt. If I say alibi, that means I'm not there. That means my client wasn't there at the aggravated robbery, say. Okay? If my client is in jail, I'm now going to have to go out and find out information to support his or her alibi. So I ask my client, I say, well, where were you on this day? Well, I was in Buffalo Wings. I was having Buffalo Wings for dinner. Did you pay with a credit card? I don't have a credit card. So you pay with cash? Uh-huh. You have a receipt? No. Who were you with? Jojo. Jojo. And what's Jojo's name and address? Jojo. And, well, what's his address? Buffalo Wings. I meet him there. I don't know him. So I go into Buffalo Wings and I ask around, being who I am, is Jojo here? And I may be dressed like Joe in a suit. Is Jojo answering that? Joe, no. One time I walked into a head shop. You know what a head shop is? To buy this leather roping for my necklace. And there were about a dozen people in there, and I looked around, and within 5 minutes, everyone was gone. And so I asked the manager, I said, what happened? He goes, well, they think you're a cop. what do you want? And you have it for free. You don't have to pay. Just leave. I want you to leave. So the same thing happens when I go into Buffalo Wings. No one's going to respond to me. Without my client by my side, I can't defend my client. And that's one of the terrible things that can happen if you can't make your bail. Okay? Now, when we look at this issue 1, it seeks to take away the power of the Supreme Court of Ohio to make rules. And the way it works right now is the Supreme Court of Ohio creates rules, suggested rules, and anybody can comment. Lawyers, any member of the citizenry can comment on whether it's a good rule. And then that rule goes to the General Assembly, Ohio's legislature, and the General Assembly can say yay or nay. We don't want it, or we do want it, we disapprove it. This issue will take that away. It will now become purely a General Assembly, the legislative body decision, whether we have certain rules and what do those rules say. And the fear is this is an effort to overrule an Ohio Supreme Court decision to Bose, which questioned the propriety of a financial bond. In that case, it started out as $700,000, very serious crime, and it was doubled to $1.5 million. Anybody here can pay 10% of $1.5 million just in your bank account? No one has raised their hands? Good. Neither could this guy. Court of Appeals made it down to $500,000, and the Supreme Court agreed with that. Certain legislators in the General Assembly thought that was a bad move, and basically this issue is designed to say financial conditions are the key. Financial conditions are the key. If, in fact, you are afraid that a person may get out on bail, so the judge imposes bail. She says it's $100,000, 10%. Does she want that guy to go out and hurt someone? Judge, the answer is no. There's a couple of reasons for that. One is she doesn't want anybody to be injured who does not deserve to be injured or punished in any way. And number two, she's an elected official. If she lets someone out who hurts someone, you can bet the next opponent against her, running against her in the next election term, is going to bring that up. And so she doesn't want that person to go out and hurt anybody, just like we don't want the person to go out and hurt anybody. So that's the conflict, that if we post a very high bond and you can't make it, you stay in jail. And you could stay in jail for months. There could be continuances. There could be any number of things happen. So you're in jail for that period of time. Your mental health suffers, your job suffers, but most importantly to me, you can't help me prepare your defense. So that's why I think you need to look seriously at this issue as to how it may impact future defendants and their ability to aid their counsel in presenting a defense of any sort. Thank you.
Thank you, Professor Carro. I think you can see while he was a highly lauded and awarded professor of law at the Akron University School of Law, Dean has also argued appeals court cases many, many times, including in the United States Supreme Court. So
let me give
Sure.
one. Joe asked you, the first thing he asked you was how many branches there are. 3 branches, right? I think it's very easy to remember them if you create an acronym. And the acronym I would create is JEL, J-E-L. Like, not quite hair gel, but you got the idea. So JEL, judicial, executive, legislative. 3 branches of government. Sorry.
Thanks. Students, put that in your notes for your credit for your class. So I was initially a public defender in law school at Gonzaga in Spokane, and I did that when I came to Stark County for several years and ran it for 4 years. And I'll tell you more about someone I hired while I was there later. When I first came back to Stark County, Ohio, I became a public defender here, and it was my pleasure to appear in front of a judge named Judge Farmer, Judge Sheila Farmer, in Massillon Municipal Court. And then it was my pleasure to appear in front of her again in Stark County Common Pleas Court, and then again in the Court of Appeals. It's been said the fruit doesn't fall far from the tree, and in this case, it's a wonderful compliment to the person sitting on my right, your left, I think, if I have it right, Judge Kristin Farmer. Judge Kristin Farmer has paid her dues. She obviously went to undergrad at Villanova and law school at Case and was a magistrate. She was an Alliance City prosecutor for a while, and then a magistrate in common pleas, and she's been a judge there for nearly 10 years. And I got to compliment her like her mom and say, you know, the reason I'm saying that doesn't fall far from the tree is they're both intelligent, fair-minded, cordial, and a pleasure to work with. Now, every now and then, of course, being a public defender, you had to have a glance from a judge or a threat of contempt now and then, but it passes. So without further ado, our next speaker is Judge Kristin G. Farmer.
Well, thank you, Joe, for that. The one thing that he neglected to mention, and probably the most important thing in this room, is that I'm also a Central Catholic graduate, class of 1994. So, Mrs. Morrison, did she send you? Will you send her my best?
There's hope.
There is. So looking at this issue from a judicial perspective, I want to kind of follow up on something that the professor said next to me. And if you are a lawyer, or if you know a lawyer, the least place you would ever want to be is sitting next to a law professor at any point in time, at school and thereafter. So, but he did talk about the rules that the Supreme Court makes and how issue 1 will take away the ability of the Supreme Court to make those rules. And I want to touch upon one rule that I use all the time, and it's Criminal Rule 46. And Criminal Rule 46 recently went through those changes that the professor was talking about. They were published for comment. The most important one being the change in the name of the rule. So the rule used to be called bond, and I think we all understand that that's what we're here to talk about. It's no longer called bond, it's called pretrial detention and release. And I think it's a little bit easier to think of bail and bond in that regard, as whether or not prior to going to trial, you are detained or are you released, and how does that happen? Obviously, when you think of detained, you think of being in a institution, whether it be the Starr County Jail or otherwise. Release, though, doesn't necessarily mean that you are out on the street, because unlike probably years before, the court now has a whole host of options available to it as technology progresses. So we have the ability to release individuals on electronic monitoring so that they can be monitored through a pretrial release program that can incorporate GPS tracking so that they can be tracked where they are if there are concerns about contact or places that they should or should not be. The court also has before it the ability to lock down somebody completely in their own home. So while they are still being somewhat detained, they are not being in a incarceration per se. The court also has the ability to have them report to a pretrial services department that we use quite often. So even though there is release, the court still has the ability to put certain conditions on the way in which they are released. And as has been pointed out, the Supreme Court has made that rule. And the Supreme Court has published for comment on that rule, one of them being, obviously, like I mentioned, the change in the name. I think it's important to point out, though, that Rule 46 went through a couple of changes. And one of the changes, when it was originally posted for comment, the rule itself said that when with respect to financial conditions, the court is to solely consider the defendant's risk of non-appearance. After the first round of comments by the public and by lawyers and people who use the rules, that was changed. And it was to that language of financial conditions shall be related to the defendant's risk of non-appearance, but additionally was added to there that they are to consider the seriousness of the offense and the previous criminal record of the defendant. And I think that's important because, as the professor indicated, this whole topic that we're here for tonight comes as a result of a decision by the Supreme Court of Ohio with respect to how the law is to be interpreted. And as many people here may have different opinions, judges themselves cannot agree. If you look at the decision, it was not a unanimous decision. It was a divided decision, about as divided as you can get for a Supreme Court decision to pass or to be put in place. But individual judges still have their own perspectives, and since that DuBose decision came out, I've gone to judicial conferences where the most heated discussion that was held at that conference was, should or can the court consider public safety when considering the amount of a bond or a bail to be determined. Some judges say the fact that the rule was changed and it was incorporated to include those two issues of seriousness of the offense and the criminal history of the offender clearly indicate that public safety is to be considered. Others take the position that, as is pointed out in the case, that it is not to be considered. So when looking at this decision, and this issue, believe that the biggest concern is the taking away of the ability to have that rule made by the Supreme Court, to have the ability to have it commented upon and to be able to be changed. In general, I will say that I'm not a big fan of making legislative change through constitutional amendments. I think that it takes away the duties and responsibility of the General Assembly. I also think it puts that change into a structure that's so hard to undo. So at some point, perhaps not this idea, but other ideas that can't be changed pursuant to changes in philosophies or changes in approaches to certain topics. I think that this article, though, Article 1, Section 9, has gone through its own constitutional amendments in the past that bring us to where we are today. And I will say also that the idea of public safety is at the forefront, I think, of every judge's mind every day. And most of the times, it pertains to the forming of a sentence in a criminal case, whether it's a probation decision, whether it's a prison term that must be imposed. And usually that decision, and if you look at it, comes post-conviction. That's pretty much when we consider that. There are times, though, where the court is required to consider public safety even before adjudication. For example, if an individual is found incompetent to stand trial but can be restored, the court has the ability to commit them to a facility, and the court makes that determination by giving deference to public safety. So there is the idea out there that the court has the ability and in certain times should be considering public safety. Another discussion that I think maybe you should know about, and Tammi Johnson and I serve on the Community Corrections Planning Board, and that's the board that Joe talked about when we got started. It's the oversight board. And what that board does, it's a group of individuals who are involved in the all aspects of the criminal justice system, not just lawyers, judges, prosecutors. It involves individuals who touch upon it. So you're talking about mental health agencies, addiction services, social services. We all come together to talk about the ways in which we can improve and unify and prioritize community corrections. And I'm not necessarily like the word corrections because anytime anybody thinks of corrections, they think of a prison, they think of a jail. But corrections isn't limited to that. It's limited to anything that can touch upon rehabilitation. Like I said, mental health, addiction services, social services, education aspects. That board, a while back, took a look. So if I go back a little bit further, in 2010, Starr County was faced with an overcrowding problem out at the Starr County Jail, which really forced us to take a look at the, I will say, pretrial detention and retention or release policies that we had. And one great thing about Starr County, and that you should all be proud of, is that the criminal justice participants always find a way to come together and work towards the best interest of our community. And they did that in this case where all the courts came together and agreed upon a bond schedule to be formed. That schedule had been in place for a very long time, and it worked very well. But obviously there are ideas that come along with changes in people's attitudes and indications of perhaps maybe we weren't doing things the right way. So recently that has been looked at, the bond schedule. It has been modified to reflect the general trends with respect to pretrial release and detention, and will continue to be monitored and implemented in the courts.
Thank you, Judge Farmer. When I asked around as to who would be the best person to represent the judiciary on this panel, several people concurred immediately. Judge Farmer, they said. And I think we'd all agree that was a really good explanation of a series of events and groups and judicial thinking. Our next speaker is someone I mentioned that I've known a long time as well. The public when you watch your television and crime dramas, which I try not to do, you always hear, you have the right to remain silent when someone is being busted. You have a right to a lawyer if you can't afford one will be appointed for you. Well, that lawyer who's appointed for you in many places is known as a public defender. They do full-time criminal defense work, and they're really good at it, most of them. And I had the pleasure of hiring Tammi Johnson before I left the public defender's office. I won't say how long ago, but Tammi immediately stood out as someone who would excel at it. And she is now the longest serving county public defender in Ohio. She runs a large office. And as you can see, she can still smile. She can still ambulate. And I don't know how, because it's a very, very difficult job. Starr County Public Defender Tammi Johnson with her perspective.
Thank you. Oh, I will. I don't know if I should say thank you, but thank you. Okay. You've gotten a perspective from a professor and a judge. Here's the defense perspective. First off, I would say vote no on this. All right? The reasons being, I take it very seriously when a constitutional amendment is proposed. It's changing the Constitution of Ohio. Okay. This is an issue that should be determined by the judges, the Supreme Court, the General Assembly. It isn't something that should be on the Constitution of Ohio. Okay. I know you might not think it, but I too am concerned about the safety of the community. But all the people who are not getting bail are still not guilty. They have not been found guilty. They have not pled guilty. And as we sit here, courts in Ohio can still consider the seriousness of the offense and the defendant's prior criminal record in determining the amount of money that they would have to post to get out of jail. The case that this started with, the DuBose case, is, and people up in arms, is because the Supreme Court of Ohio said in determining the amount of money that you require a defendant to post, you can't consider the safety of the community. That's all they said. You can certainly require them to have an ankle monitor or whatever else will control them. House arrest, monitored, of course. Okay. But the amount of money just means if you're wealthy enough, you get out of jail. And anything besides a capital murder case, if you're wealthy enough, you can get out of jail. And if you haven't figured it out, I'm the public defender. That means everyone who my office represents is indigent. And it's not just me saying, oh, you're indigent, you're poor. There are guidelines, et cetera, you have to meet. And they're low, I can tell you, okay? If you make $1,200 a month gross, you don't qualify for us. How's that? Gross, all right? Having somebody with a high cash bail does not ensure the safety of the community. And I can give you an example. And I'm not going to use names, but I believe Judge Farmer knows since I tried the case in front of her. Gentleman was charged with a felonious assault against his current or former. I thought it was current, but having difficulties. Wife. It was alleged that he ran into her car with his car, okay? And she was not seriously injured, but it's a felonious assault if that's true, if that's proven, etc. And he came before the municipal court, which is where we start. You need louder?
Louder, please.
Okay.
Let's lift this baby up.
So we came in front of the municipal court judge who set a bond of $100,000. All right? Now, again, I don't know about you, but I couldn't post a $100,000 bond to get out of jail. Well, this person had a family member who agreed to do it and posted it. And he got out of jail. $100,000. And about 3 weeks afterwards, maybe not quite that, he killed his wife. He shot her. Didn't keep her safe. Even though there was a high cash bail, it didn't keep her safe. There has to be other ways to keep people safe other than monetarily. All high cash bails do is say, if you're poor, you get to sit in jail. And I have seen recently, within the last year, folks who are charged with a disorderly conduct, which is screaming in the street, or, it's a misdemeanor of the 4th degree, the lowest misdemeanor you can have and still have to do jail time, maximum of 30 days in jail. I've seen folks that bond is set at $100,000. Why? Because they didn't appear for court twice. They were let out, they were arrested, they were let out, they didn't come back to court. They were picked up again, let out, they didn't come back to court. So that's when the bond is set high. There are ways to ensure public safety without causing poor people to populate the jail. And while you've heard both the judge and the professor say that, if you're in jail, you have mental health issues that occur while you're in jail, you lose your job, you can't pay your rent, you lose your kids in most instances. Because guess what? You're not there to take care of them. And let's say you get found not guilty of whatever crime you've been charged with, and you get let out. You don't get like a bonus. You don't get like, here's $20,000 that you didn't make while you were out so that you can go and find someplace to stay. No. You don't have a house, so your kids have been taken by the Department of Job and Family Services. So there you go for not having been guilty of anything. That's where I'd like to end. All right? I think you should vote no on this because I think it's unnecessary and it just keeps poor people in jail.
Thank you, Tammi Johnson. I am proud I hired you. You know, when you think of people who are arrested, those people in jail, you're not thinking about your son, your sister, your brother, your father. You're thinking about those people. But when you find yourself arrested and facing a potentially high bond or facing a charge that could end up in jail or prison, you want someone who's passionate about defending you. It's not easy being a public defender and going to social occasions. Ew, how can you defend those people? Don't you feel bad if you get them off?
No.
Not understanding that this is the person who passionately makes sure that person remains a human being, and that the prosecutors cross their T's and dot their I's to get their convictions. Moving on to our final presenter, I am also proud I hired this person, because after I left the public defender, I went to the Canton City Law Department. Initially, I wasn't in charge. That took a while, but for the 18 years I was there, I worked with Jason Reese for 5 years. He was a graduate of the Akron School of Law, a guy who'd done a lot of things in life and wasn't afraid to take on challenges and tough cases. He is, at the time, he was also working a family law practice part-time and working for the city. When I brought him from the criminal division, he was a prosecutor for 5 years. And then I brought him to the civil side, the non-criminal side, where he took on a lot of complicated cases that he had to enforce on a part-time basis. And he worked in family court, where he gained a reputation as being someone who cared about his clients and working hard. So we got to work together for over 20 years. Jason's also a graduate of the Ohio University, and he is our current first full-time Canton City prosecutor for the last 4 or 5 years. Mr. Reese.
Thank you, Joe. Hopefully everybody can hear me. So I would say that of the distinguished guests up here, I have the hardest job up here. And here's why I'm going to tell you that. It is a big responsibility to be a prosecutor. So police officer comes in and wants to review a case. So I have to make a determination. First of all, is there probable cause to go forward? I take that complaint, I go down to a judge, and I explain to the judge why I think charges should be filed. With that also comes, as the case progresses, whatever type of case it is, I do municipal court, so I'm doing misdemeanors of the first degree. What we see are a lot of assaults, domestic violence. We also have a program through our court where we handle felonies when they first come in. We run what we call statuses or a preliminary hearing. That's also probable cause. So at this point, we're making a determination as to, one, whether or not a case should go forward. Should I keep it a misdemeanor? Should I send it over as a felony? Now, I was fortunate to have good bosses. And my one boss, who at the time when I was a young prosecutor, was Judge Frank Frascione. And Judge Frascione, when he was the prosecutor, used to always tell me that you owe a responsibility not only to the victim, but to the defendant to make sure that you are doing the right thing. In this business as lawyers, as a prosecutor in private practice, there are a lot of lawyers that I just don't like. And he would tell me to make sure that you are making your decision based on the facts of the case and the law, not on the other person's personality, not on the race of the defendant, not on the amount of wealth they have. Whether it's a Timken or whether it's a Jones, it doesn't matter. You have a job to make sure that you are doing the right thing. And the day that you can't do that is the day you should no longer be a prosecutor. So I've always taken that to heart, and that's always been important to me. So here's what I would say about this. I wear 2 hats. I have my lawyer hat, and I have my prosecutor hat. Now, they're both lawyers, however. As a prosecutor, I love this bill. So here's what this is like for the state of Ohio. It is like that, we'll use a football example. Imagine if every time McKinley took the field, they were automatically up by 14 points. With this, I will automatically be up by 14 points. Would you agree, Tammi?
At least.
At least. She would say 21. As the lawyer in me, and this is hard for me that I would actually have to agree with Professor Carro about something. You know, the fact that the legislative branch of our state of Ohio did this is lazy, is what this is. I would tell you as a lawyer that I don't like, and I agree with Tammi on this, I'm having a hard time today, that when you amend the state constitution, that is a big deal. And you need to make sure that you think long and hard, because think about it. It's different when we as the citizens all get together and say, we want to change something, and we're going to make you, legislative branch, do your job. This is them saying, well, you know, here's what we're going to do. We're going to do this. So as the lawyer in me, I don't like that. As the prosecutor in me, I love this. So some of the things that we deal with, as Joe used the term, he said, those people. So, but also remember, though, that some of the people who were injured, some of the people who were beat up or assaulted or murdered or raped, those might be you. Those might be your family. That might be your daughter. And it is important to protect the citizens. It is important. What I know is, and I have practiced law, I think at one time I counted at some point, there are 88 counties, and I think I've practiced law in 15 or 16 of them, from big counties to little counties. I've done criminal law. At one point, I was a criminal defense attorney for a short period of time. I didn't care for it. It wasn't my speed. I know, right? But I did win the trials that I tried. So what I do know about our judiciary, especially here in Stark County, because that's who I deal with, these are men and women who take this job serious. And it's easy to be a prosecutor. It's easy to be a defense attorney. It is tough to be a judge because you got to make important decisions. As a lawyer who is not a judge, it's easy for us in the sense that we pick a side, we pick a team, and we do what we have to do to win our team, provided it's ethical, provided we're not cheating. That is easy. And these judges make their decisions, and sometimes they look at the facts and everything looks good on paper, and someone gets out and they do something horrible. And then what happens is everybody gets up in arms and everybody wants blood. And remember, at the same point, if you're the individual, as Joe said, who's charged or your family's charged, you want to make sure that your child is taken care of or your brother's taken care of, and he has fair access to the courts, to the good criminal defense attorneys that we have. If you're the victim, you obviously want to make sure that the state does everything they can to protect you. So I say this, that it is very good that we have the judiciary that we have here in Stark County. As citizens, we can be very proud of these people. You know, this is my lawyer hat is, this is a cheap way to try to fix judicial reform. Putting people in prison or putting people in jail or letting them out of jail is not judicial reform. If you want true judicial reform, it has to start at home. And what I mean by that is criminals are made at a young age. That's where they're made. You take a child who has childhood trauma, and you add certain factors. You add a missing parent, domestic violence in a home, alcohol or drug addiction, a lack of good education, racism, poverty, and that's like making a cake. And that cake will turn out to be a criminal. Not every time, but if you look at criminals, people who've done terrible things, people who maybe not even do terrible things, but is somebody I would call a thug. Someone who's out there cutting tires, throwing rocks through windows, stealing, just low-grade felonies, but have a record that thick. And there are people in this town that have records that are pages upon pages upon pages. And they go away to prison for 6 months or 18 months, or they go to jail for 60 days. Those people, you look at those people and you look at the hardened criminals, it all comes back to childhood trauma. So, again, as a prosecutor, I absolutely love starting out 21 points ahead. I think it's great. as somebody who went to law school and understands the law, I just think this is a cheap way for our legislative branch to sidestep an important issue. So with that, please don't ever tell anybody that I agreed with J.D. and Carro or Tammi Johnson. Thank you.
Thank you.
Don't tell anybody.
Thank you, Jason. I'm proud of the folks that are on this panel. I promised you would have a quality panel and get different points of view about this issue. I think we are fulfilling that. And I also said we were going to leave, per our instructions, at least a half hour for questions and answers from the League of Women Voters and the audience. Sure.
Two things I wanted to add are this. In some ways, this effort is based on a false premise. There is a statute in Ohio that allows for a judge to say, look, this guy is so dangerous in my view, I'm not going to grant him bail. It's called preventative detention, so the person doesn't get out, doesn't get a bail. So preventative detention is an alternative to a high bail amount. And the second thing is, I think Jason's job is actually the toughest job. You've heard about the Department of Justice recently, DOJ in Washington, D.C. Engraved deeply in the wall of the entrance to the Department of Justice is the phrase, the government prevails when justice is done. My job as a criminal defense lawyer is to represent the defendant. His job is to ensure that justice is done. That's a tougher burden. So he's diminishing that a little bit. He shouldn't. It's a very tough job. Thank you.
Okay. Panel, thank you very much for finishing up on time. We have a lot of questions. Did you want to say one more thing?
Well, I just wanted to follow up with what the professor said about this preventative detention, and just to let you know that there, with respect to that tool, for lack of a better term, that is given to judges, it only applies to certain offenses, and it's non-capital aggravated murder, any felonies of the first or second degree, felony vehicular homicide, or menacing by stalking, and felony OVIs. There is pending legislation. The House and the Senate have both proposed bail reform bills. They are identical in nature. The House bill has undergone some revisions to make it a little bit more workable, and I think that that's the one that will probably be pushed through. Yeah, worked on most, I guess is the best way to say it. But one good thing that it does is it expands that category of offenses that the courts have the ability to do that preventative detention, to include offenses, because to be fair, probably lower offenses, maybe as Tammi probably said, the lower offenses ones are sometimes the ones that escalate, and they're sometimes the ones that cause the biggest concerns. So I just want to throw that there is pending legislation out there that the General Assembly does recognize the need for bail reform, pretrial detention, retention, release, however you want to say it, without the necessity of the amendment.
Okay, and actually that's a nice bridge to this first question, because you're talking about the role of the legislature. But Joe started off by saying that basically this proposal came from the state legislature. It's taking responsibility away from the courts and switching it over to the state legislature. And the question submitted was, what checks and balances are built into this amendment?
Sounds like a professorial question.
No, when you look at the legislative branch, especially in Ohio, it's very political. We have accusations of politics in the Ohio Supreme Court as well, but the people who run in the General Assembly run as politicians, run as representatives of a party. So it places in the power of the within the power of the General Assembly the ability to pretty much do whatever they want to do. And the only branch that checks that is the judicial branch, whether it be the Ohio Supreme Court or if it gets to the federal system, the United States Supreme Court. So the general view is that General Assembly is going to do what it wants to do.
So that's not answering the question.
Oh, I'm
unless-
sorry.
So the question was, what checks and balances
None.
are built into it?
There are none.
Zero, zip, none.
Zero, unless it gets to the Supreme Court, zero.
The Ohio Supreme Court or the U.S.?
Correct, Ohio or U.S.
Okay, got it.
But on the bail issue, it's very hard to get a case in the United States Supreme Court because excessive bail is usually a pretrial, pre-conviction issue. So unless you have a conviction, you're usually not going to get to the U.S. Supreme Court.
Cute. Okay. Catch-22. So the next one, it relates to a question that was in my mind, and it's, Judge Farmer, maybe you can take this one. The question is, what data gave rise in Ohio to the public safety concern? And it kind of goes with my question about, you had used a phrase, the bond schedule, that the bond schedule changed. So how do you assess, like, the before the change on the bond schedule to the after, and what data goes into making recommendations like this about public safety?
So I guess I should maybe, when I say bond schedule, it probably is an outdated term by what they operate under now. And it's generally low-level offenses, nonviolent offenses should be released on their own recognizance without the posting of any bond or without any supervision. If there are certain factors that should be considered that raise a concern, officers have the ability to contact or prosecutors contact judges and ask for the bond to be increased. Hearings can be held. I guess this whole issue, I would say, wasn't necessarily driven by data so much as it was by the decision from the Supreme Court. This issue comes directly as a result of the decision by the Supreme Court and the fallout from that over some people who really disagree with it, and that's how they took the easy way out and to make the change. When we, on the Community Corrections Planning Board, addressed the issue of a change in our approach to pretrial release and detention, it was more a reflection of the fact that notions on the pretrial detention and release had changed since we had taken a look at it originally, and also with recognition of the fact, as I said, technology has expanded. It's given us better tools to be able to use as opposed to money. I hope that answers the question.
Okay. And as luck would have it, it refers, its connection to this one. And this is, I guess, for Tammi. In your example, the person who did not return to court twice and therefore had to post the $100,000 bail, what would you recommend as a non-bail solution?
Better monitoring from either the pretrial release program or house confinement. Now, to be fair, and I want you to know this, he was held for, I think, 4 days, and then he pled guilty to his charge, and as is not unusual, got a suspended sentence with credit for the time that he had done. And I don't want you to think I'm saying that the judge was wrong in this. I'm just saying that if he'd have showed up in court like he should have, he'd never been in jail at all, because the judge would not have sentenced him to time in jail. Would you agree?
I would.
Oh, okay.
I agree.
Yeah.
You agree again with her?
Yeah. Hey.
Cut the tape.
But it's just some money. Let's say that they set a money bond that he could make. That doesn't mean he's going to show up anyhow.
Right. So the other proposals that you had would be better with the monitor.
Yes.
At least you know where he is.
Yes.
Go get him. Okay. There is a suspicion among some that this amendment is intended to increase the number of people held in jails and perhaps even lead to building more bigger jails in Ohio. Who would like to address that suspicion?
Or bigger jails?
Right, because the suspicion was that if the legislature is then getting more involved in posting bail higher, or requiring higher bail, then more people are going to be sitting in jail.
It's very expensive to build a jail. I've been involved in two buildings, two new jail buildings. It's very expensive. There's no incentive for the government to do that. I think what it is it's a fear from the members of the General Assembly that people will have a low financial bond, get out and hurt somebody, and they don't want that. They want to be seen as protectors of the public. I think it's pure and simple a political reason.
I would just add to that, if in fact that was the intention, it wouldn't have fallen, or wouldn't come up after the DuBose decision. I think that if that was the intention, it would have been put out a long time ago. Whereas I think that it's more reaction to a decision by the Supreme Court than any conspiracy.
Absolutely.
Okay. So it's unlikely to have any connection with trying to get more people in jail and building more
No,
jails.
it doesn't create any revenue for the state. I mean, if you put a person in jail, you have to build a bigger, better jail, let's say. It's expensive. And you have to meet certain federal guidelines now as well.
Said one who has spent time in the jails.
A lot of
Okay.
time.
Okay.
Probably.
Will passage of issue 1 make future changes to criminal justice reform more difficult? So if this passed, Judge Farmer, would people, and Tammi, would you be able to get together as you have been and look at different alternatives to bail, mental health training, treatment, or education or something? Would this inhibit those more creative approaches?
Well, and I think in certain areas it might. I don't necessarily believe in Stark County it would, just because we all have the best interests of the community in mind. But there may be other places in the state that are more divided and don't work as well as the partners in the criminal justice system in this county do. So as far as a community corrections planning board perspective, I would say no. I would hope no, I guess I should say.
May I answer part of that?
Oh, sure, please.
The committee the judge is speaking about is a body that is designed to prevent problems. It's designed to have communication between the state, the prosecutor, the defense counsel, the judges, and create a system that doesn't cause a problem. In reality, the only change that usually comes in the criminal justice system is when there's been a wrongful conviction and somebody appeals it, and you appeal it to the Court of Appeals, your 5th District, for example, or to the Ohio Supreme Court, or to the federal system, and then changes occur. I mean, look at Miranda. Miranda was not something that the United States Congress or the Ohio General Assembly created. It was created by the courts. My view is that's the only way you get real change.
Miranda being the aforesaid reference on television. When you're arrested, you have the right to remain silent. If you can't afford an attorney will be appointed for you. That came out of 1965 or 66, Miranda versus Arizona. Am I right, Professor?
Something like that.
And initially, police didn't like it. They didn't like being told they had to tell a suspect their rights. They didn't like the fact that they might not be able to use some of the techniques they had been. But in time, they really liked it, because they found it was easy sometimes to get people to confess if it was on their conscience, or it just, and it was a better confession if it was voluntary and, made knowingly and voluntarily. Thank you.
I would disagree with that the police like it. I'm not saying all, I don't want to generalize, but I've had too many conversations with police officers of, we have to say this stuff, and we know they did it, and, you know, if I don't say the exact words, then some judge is going to say I can't use his statement, and am I wrong?
You're wrong.
Okay.
Please never say that.
Well, let me just add something from the Supreme Court. When the United States Supreme Court decides Miranda, it's designed to protect the individual who is in custody, held incommunicado, without communication, custodial interrogation. But what the court later says is a waiver means I give up my rights. The court, United States Supreme Court has said that a waiver can be inferred. So in other words, if the guy just sits there and doesn't say anything, and then eventually says, yeah, I did it, and doesn't expressly waive his rights, it can be inferred that he waived his rights. On the other hand, invocation, that is the creation of the right, has to be expressed. So I have to say, while I'm being questioned, I do not wish to speak with you. I want my lawyer, Tammi Johnson, here. That's an express invocation. On the other hand, the waiver can be guessed at, right? That's not good.
No, I don't agree. But I just want to circle back to the actual question that was asked, because we've gone far afield. I think operationally, though, if this, say, issue 1 is passed, operationally, I think you'll see this be more effective in smaller jurisdictions, because, look, at the end of the day, there are only so many jail beds that can hold people. So we can try, as a prosecutor, and Tammi would agree with this, I always say that people should stay in. Not always, but what would you say, 99.9% of the time?
At least.
But that's my job. Some decisions I just think shouldn't be up to me, they should be up to the judge. We all play a role. She's going to say you should get out. My job is to say 99.9% of the time they should stay in. And Judge Farmer's job she gets paid the big bucks to make the big decisions. So we all play our part. So realistically, I think even if this is passed, places like Stark County, Cuyahoga County, Hamilton County, Columbus, what's Columbus? Franklin County, there's only so many jail beds to go around. And we here in Stark County, and the judge would agree, we have an overcrowding problem at the jail sometimes. And I know I get yelled at all the time, and I say, well, that's good, but I'm not the sheriff. That's your problem, and I got my problem. We all got a job to do in this dance. So although if it does get passed, I honestly don't think you're going to see that much of a change in the bigger communities, because Judge Farmer's still going to make her decision based on those other factors, Rule 46, and those other factors. So that doesn't mean that I necessarily support it. I just think operationally, I don't think it'll be much of a difference. Do you guys agree or disagree with that?
Okay. Interesting group you assembled here today, Joe. Okay. Someone has kind of a general question, and Jason, maybe you can answer this. What's included in a person's criminal record, such as simple possession of marijuana or juvenile record?
Everything you've done, I can find out. We get a leads report, or we'll get a criminal report, and it'll have juvenile convictions. It will have your driving record, potentially, every speeding ticket that you've gotten over X amount of years. If you had a DUI 40 years ago, I can find it. Sometimes I may not be able to have it, but I can look at a certain form, and if you have a FBI number or a BCI number, I know you've done something. I may not know what it is, but if you've never been in trouble before, you do not have a BCI number, and you do not have an FBI number. You know who has those? Criminals.
What does BCI stand for?
Oh, Bureau of Criminal Investigation. I'm sorry. And obviously everybody knows who the FBI is. So there are numbers, and I can look at things, and I can say, well, Judge, clearly this person committed a crime. I don't necessarily know what it was. It must not have been Stark County, or I can't find it on leads. Maybe it was in, I don't know, New York. Maybe it was somewhere else. So if I see that, the other thing is I can list all your failure to appear comes to me. So I know if you missed coming to arraignments, how many times you missed. If you failed to show up for your speeding ticket, I know. If you failed to do community service, I know. If you failed to follow through at Quest, I know. So I know all those things. And what I do is I look down the line and I count them. And I'll say, Judge, this person may only be charged with F5 possession of drugs, but he has 35 failure to appears. He's probably not coming back to court. And what you have to understand is a lot of these people that Tammy deal with, not only are they poor, they're dealing with mental health issues, they're dealing with drug addiction, so they're probably not coming back to court. I mean, if you are a person with mental health issues who is using and abusing drugs, you're probably not going to know it's Thursday. That's what happens. And these people don't necessarily not come to court because they're like, I don't want to come to court, screw that judge. They're coming to court because they're going through some hard times. All that being said, that's her argument, and my job is to say, that guy's got to stay in because I need him at court. The other thing we'll see, especially with drugs, is I'll have family members come to me and say, look, I would like you to argue a bond. You need to keep my son in because I know if my son gets out, my son's going to continue to use heroin and he's going to die. And the only hope is you keep me in that jail for a couple days so I can find a place to put him so we can try to sober him up. We see that. I see that a lot. I probably get that call multiple times a day from parents. The other thing we see a lot is the domestic violence, women coming to me saying, I know if he gets out, I know he's going to kill me. Domestic violence is on the uprise all through the United States, including Stark County. And on average, it takes, men can be victims of domestic violence, but traditionally it's women. Traditionally, you'll see a woman will have to be abused 13 to 14 times before she will even make a report. And that doesn't mean she's going to follow through with it. She's just going to finally call the police. So, it is dangerous to be a woman in America. So,
For a lot of reasons.
yes, it's dangerous.
Okay. One person is very concerned about the wording in the the proposed issue one. Quote, any other factor the Ohio General Assembly prescribes, end of quote. Why isn't this overly broad? What limits are there on any other factor? Who wants to tackle that one?
I'll start and let the others. Again, we're back to the whole 3 branches of government, separation of powers, checks and balances. That's a dangerous phrase, in my opinion. I'm a firm believer in the separation of powers. It's taking the power away from the court system, which, as you now know, having heard from everyone, this is where the sausage gets made. This is where human beings have to come and their fates are decided. And the people who can best do that, and yes, this is an interesting panel because when the truth is supposed to emerge when the smoke clears. You've got an advocate for the state or the city, strong advocate for the defense, well trained by law school professors, in front of qualified judges, all with rules and guidelines that already tell them how they set bail, how they decide whether. It used to be the only thing that matters was were they going to show up. And then it evolved into all these other factors. So, in my opinion, the answer to that question is that's dangerous language, in my opinion.
Okay. One last question, and we're going to be right on time here. In light of all that you've talked about these proposed changes, how could you guarantee that bail reform and justice will be applied consistently if the procedures are no longer overseen or set by the Supreme Court of Ohio?
You can't.
Short answer.
Okay. Well, this has been a remarkable panel here. Would you please join me in sharing? So students and adults, thank you all very much for joining us this evening. We would appreciate your completing the evaluation form that I hope you found on your chair, or if you don't have one, a league member can get one to you, and then leave it on the back table as you leave. We are very grateful for this space. This is the 3rd event we have held here, provided by the Canton City Schools, and for the technical assistance of Bill Widener and his team. I want you to know that we have reserved this space only until 9 o'clock. Then the building crew was going to prepare the room for tomorrow's students. We'd love it if you stay and chat, but please go by 9. So as I mentioned in the opening remarks, that we are a nonprofit organization. Our education fund is tax-exempt organization. Our work, as with all nonprofits, is accomplished by generous donations from members and friends who value the work we do. If you are inclined to help us make democracy work, please contribute by dropping a cash donation in the basket at the back of the room, or we accept mailed checks, and I think we have some pre-addressed envelopes in the back. I just want to have one comment that what happens on Tuesday, November 8th? Election Day. So voter registration already ended this past Tuesday. Absentee ballot, absentee voting by mail started yesterday. You can still apply for an absentee ballot. Early in-person voting is now available from 8 in the morning till 5 p.m. weekdays at the Board of Elections office over on Route 62 east of Canton at Regent Avenue. Then the closer we get to November 8th, the hours are extended. You can find more times and so on at the website of the Secretary of State. So my final wish for you is that you make sure that you and everyone you know votes on November 8th. Thank you for joining us tonight. Have a safe trip home. So, thank you. Thank you.